Welcome everyone to Conn Maciel Carey's monthly labor and employment webinar series. Today, Megan Shackett and myself will be discussing avoiding common pitfalls of company trade secret and non-compete and non-solicitation agreements. With everything else going on in the world the past year or two, issues with non-compete and non-solicitation agreements may not be in the forefront of your mind unless or until you're embroiled in some sort of dispute regarding trade secrets or non-compete agreements, and all of a sudden then these issues become crucial. At the same time, even though we may not have been thinking about these issues so much the last year or two, there has been a ton of updates from various state legislatures, and even federally there has been some movement. So if somehow it's just been under your radar, not realizing what that there's been any movement on this, you might be in a state that all of a sudden is now prohibiting non-compete agreements. So Megan and I just thought it would be prudent to go through this topic with you, remind you about the positives, the negatives, what you want to be thinking about in this regard, and importantly, provide you with some updates about what is the current status of the law and what may be changing, so that you know whether your current business practices need to change with regard to the non-compete agreements. So what I'll be doing, or what Megan and I will be doing, is we'll give a discussion about just generally how you want to protect your trade secrets. Then we'll move into how your non-compete agreement should be utilized during the hiring process and on the flip side, the termination process. Then I'll walk through the legal update of what's been going on in the last 18 months or so that may be very different from what has been going on in the past. And then I will give you some specific tips for how to deal with choice of law provisions and form selection clauses while you are drafting your non-competes or while you are revising your non-competes, just so that you make sure to take advantage of the most advantageous laws that you can, because every state is so different in this regard. You really want to make sure to take advantage of the favorable states that you can while you're dealing with these types of restrictive covenants. So you know who I am. For those of you who don't know me, my name is Jordan Schwartz. I'm a partner here at Conn Maciel Carey. I focus on all aspects of labor and employment in litigation at both federal and state levels, in all matters relating to restrictive covenant issues, the ADA, the FLSA, the FMLA. I counsel employers on all issues relating to hiring, discipline, internal investigations, termination, and restrictive covenant issues. And of course, like many employment lawyers now, I advise on all issues stemming from COVID-19. And now you will hear from Megan, who will introduce herself and then who will start the presentation.
Thanks, Jordan. Hi, everyone. I'm Megan Shackett. I'm an associate in our Conn Maciel Carey San Francisco office. So I practice in both our labor and employment groups and our OSHA groups, handling our California OSHA matters on the labor and employment side. I handle litigation in California state and federal court, and also counsel employers on all sorts of employment issues, including the ones we're going to discuss today. Lately, it's been a lot of certainly COVID-19 advice, but also keeping up with all of the constant changes in California law. So today, we're going to dive right in. And before we get to the much anticipated legal updates I'm just going to go over kind of some foundational concepts to remind everybody what it is we're talking about, so those updates make a little bit of sense. And the first topic is on protecting trade secrets. So this is something that is, when COVID is not the only thing that people are worrying about, this is often actually top of mind for companies to protect their trade secrets. So what are we talking about when we use the term trade secrets? There are, in today's presentation, we will highlight when there are major differences from jurisdiction to jurisdiction, but we'll try to kind of give an overview that would, so if depending on where you are nationwide, this presentation makes sense. And one interesting thing to note about even just the definition of trade secrets is that there has been efforts to have a uniform standard nationwide. There is a Uniform Trade Secret Act that has been adopted by the vast majority of states in an attempt to have a common definition of what a trade secret is. But generally speaking, a trade secret is information that is not generally known to others and that gives an employer a competitive advantage. So you have to think about both the information actually being confidential, and you have to think about the value that it holds to the company. And, the flip side of that is kind of the risk in what's at stake if that information were to be shared with a competitor. So the kind of corollary to that we'll talk about in defining a trade secret is the efforts to maintain its secrecy. And what we'll kind of dive into these concepts in a little bit more detail, but some general considerations to keep in mind as we continue through the slides are those kind of general idea of it being confidential and the value to the company. So despite what I just said about an attempt to have a uniform definition, it is can be kind of a hard concept to pin down because it is so fact specific. So you really have to look at the nature of the information and how it's used. And so some of the things that courts will consider in determining whether information is a trade secret or not is whether the information is known outside of the business. Is this really something that's kind of a secret internally, or is this generally held information in the industry or in a certain kind of business? What are the measures taken by the company to protect the secrecy of this information? Like I mentioned a moment ago, what is the value of the information to both the owner internally to their operations and also to the competitor? So what's that risk of that information being shared? Another thing that courts will look at is the amount of effort and funds that are put towards developing and protecting the information. And then how easy or difficult would it be for this information to be acquired or duplicated by others? And how those factors are interpreted from jurisdiction to jurisdiction matters because depending on where your employees are working, how the courts have interpreted these factors in that jurisdiction is going to be what determines whether or not information is considered a trade secret and kind of rises to that highest level of protection. So when we talk about, you often hear the word, like the phrase confidential, proprietary, or trade secret information. So you can kind of think of confidential information as being a really broad category and trade secret information being within that category. So something may be confidential and you may treat it as confidential, but it may not rise to the level of a trade secret. So examples of things that have been considered trade secrets in the courts are things like customer lists or formulas, manufacturing processes, marketing plans, pricing information, internal studies like research studies or processes, strategic business plans, testing data, and training manuals. And this is not to say that these categories will always constitute a trade secret, but these are examples of things that have been considered a trade secret.
Yeah, and
So,
just to build off that point, you need to look at this list in the context of what Megan said in the slide before about the factors that a court would consider. So for customer lists, for example, if your company has treated the customer list as confidential and private and has not disseminated that list anywhere, there's a better chance that a customer list would be considered a trade secret. But if your competitors know your customer list and if it's published somewhere, then all of a sudden customer list is in no way, shape, or form a trade secret. So you have to look at these examples again in conjunction with what Megan just explained for the various measures that you as a company must take in order to show that you value this information and that it's private to you.
absolutely. So another key example we like to give is, let's say, customer lists. Let's say you just have a generic list of all of the potential customers in your industry, and it could be readily found by a quick internet search, versus a customer list that actually has key contacts within those customers. And those key contacts, you wouldn't be able to find those people just by Googling the company on the internet and having a roster of employees. Let's say those individual businesses don't make that information readily available. So those are the kinds of really, really fact-specific inquiry, a really detailed inquiry that a court would get into if this were really to be a litigated issue. So one of the factors that we talk about is protecting the trade secret. So how do you go about doing that? The key here is that the company really wants to take affirmative steps to both communicate with its employees what is the confidential information that the company is trying to protect, and then also what are the steps that are expected of the employees to protect that information. So one way that this is often done is through a confidentiality agreement that's signed at the beginning of employment, and it can also be repeated in a company handbook. And this can just very clearly, in easily understandable language, lay out what is the information that is confidential, what is the information that's trying to be protected, and what are the obligations of the employee. So, not to disclose it, certain restrictions on how to use it, and then depending on where you are and what your jurisdiction permits in terms of restrictive covenants, it may even go as far as restricting the ability to solicit customers and employees. And oftentimes, even though the confidentiality agreement and handbook are often reviewed and signed at the beginning of the employment, the reality is that oftentimes these don't become an issue until an employee has left a company and is now potentially with a competitor. So the agreement, another key thing that the agreement or the handbook can describe is an employee's duty to return confidential and proprietary information at the end of employment. And we'll talk about that in a little bit more detail in a little bit. So not only is it important to lay out very clearly the expectation, but it's also important to have steps to really protect the information physically, right? If there are printouts of this information, or if there's a physical thing that we're talking about protecting, that it's labeled as such and that access to it is restricted to only those who need to access it. And if we're talking about information that's available on software systems, computer systems, then making sure that there are adequate protections like password protections, software programs that would protect it, or whatnot. There are also steps that you can take to protect the information internally, like limiting access to the information to only those who need to have it and access it, and considering restricting access to those who really don't need access to it. Same thing with circulating documentation. If an email is going out and it doesn't need to go company-wide, it only needs to go to the people who are using that information, then that's something to pay attention to as well. And recognizing that how information is being developed and used may change over time. It's certainly a good practice to take periodic inventory of your trade secrets and your policies and practices in this area and consider whether any changes need to be made. And then, of course, communicate those changes to your workforce. And if you were ever in a situation where you're, let's say, having a meeting in a conference room and you're actually printing out or sharing information that is protected, that you make sure that those printouts don't end up sitting around on the conference table after the meeting is over. Another kind of subset agreement that is sometimes considered along with just a generic confidentiality agreement is, confidentiality, but also non-disclosure agreement. And the scope of a non-disclosure agreement in terms of what is permitted and kind of the standard that applies for whether it's a proper agreement or not varies state by state. For example, as a California lawyer, I know that California has, not surprisingly, quite a few restrictions in this area in terms of all of the restrictive covenants that we're talking about today, but the non-disclosure agreements is an area that it has specific restrictions. So this is something to definitely look at state to state. And if you are operating in more than one state, maybe it makes sense to have different agreements for different states where employees are operating, or maybe it makes sense to have, whatever state is the most restrictive and have that apply to your entire workforce, depending on what makes sense for a company. So again, recognizing that there may be some variety state to state, typically when a court looks at it, whether or not a non-disclosure agreement is reasonable, they're going to look at several factors, including the interests of the disclosing party in keeping the information secret, also the period of time that the information is being asked to remain secret, the burden that it places on the party to maintain the secrecy of it, and the general interests of the public. So the courts will consider all of these, but then at the end of the day, they'll also keep in mind whether the information being asked to be protected is actually confidential. And it's important not to lose sight of that, because oftentimes, and it makes sense, companies want to be very inclusive in kind of putting a circle around the confidential information, but recognize that some of the information that a company might sweep up might not actually be confidential, and it might behoove a company to be more selective in the information that it's trying to protect, so that if there were ever a dispute, you can make clear that you really are trying to protect genuine secret information. So moving on kind of from trade secret confidential information and what that is, and there's also the concept of having a non-compete agreement, both at hire and sometimes even during the middle of an employee's employment relationship. So when we talk about a non-compete agreement, we're talking about either a part of an employment agreement that includes a non-compete clause, or a standalone non-compete agreement where an employee is essentially agreeing not to compete with their employer after they've left the employment relationship, and even during the course of the employment relationship. And again, this agreement oftentimes is signed at the beginning of employment, or even in the middle during the course of employment. But when it really comes into play is after an employee has left. So where a non-compete agreement is permitted, and they're not valid nationwide, we'll get into that in a moment, but where they are permitted, they're often considered to be valid when there's three factors that are present. One, they're supported by consideration. Two, they protect a legitimate business interest of the employer. And three, they're reasonable in scope, geography, and time. And just a note on the consideration, something to keep in mind is that depending on the jurisdiction, there may be a difference in what constitutes adequate consideration, depending on whether the agreement is entered into at the beginning of the employment or in the middle of the employment. So oftentimes, just being hired is enough adequate consideration for the non-compete agreement at the beginning of employment, but it varies state to state if the non-compete agreement is presented to the employee during the course of their employment relationship.
Yeah, just to expand on that just a bit further, we have lots of clients asking, oh, yeah, we've had this employee for 4 or 5 years. Now we want him to enter into a non-compete. We do that, right? And the answer that lawyers love to give is it depends, because as Megan said, in some states, just saying, okay, you're still an employee, you're continued employment, that could constitute sufficient consideration. So fine, you can have the employee sign the new non-compete, but there's a handful of states where continued employment, regardless of how long that employment has been for or will be for, does not constitute adequate consideration to enter into a non-compete. So in those cases, typically you have to give some sort of bonus or raise or change the employee's job title and promote the employee. And then typically that's akin to a new employment relationship in some way, at least in this context, and that should constitute sufficient consideration. But just deciding you want to have an employee sign a non-compete agreement in the middle of his or her employment isn't necessarily the way to go, depending on what state you're in. Sorry to interrupt, Megan.
No, I appreciate it. Thanks, Jordan. So where there are certain states and jurisdictions, you'll hear from Jordan a little bit later about an update from Washington, D.C. There are certain places where non-compete agreements are not permitted at all. California being one of them. Oklahoma and North Dakota are among the list also. So, just as an example, in California, non-compete agreements have been prohibited since the 1800s. There's a specific statute on point, and it continues to be interpreted pretty broadly to prevent restrictions. And the concern is restricting trade, essentially, and a worker's ability to perform their chosen profession and even, follow their personal interests if their profession changes over time. So even in jurisdictions where non-compete agreements are permitted, courts are still going to scrutinize non-compete agreements to make sure that they aren't too restrictive against trade, essentially. And so it's important, even if you're considering a non-compete agreement where they are permitted, that the non-compete agreement be reasonable and be narrowly tailored to address the true concerns. And this brings us to the topic of a legitimate business interest. So again, regardless of how well a non-compete agreement may be written, at the end of the day, no court is going to enforce it unless the employer can identify a legitimate business interest that the restrictive covenant is protecting. And what a legitimate business interest means can vary and is subject to court interpretation. And as many of these things are a multi-factor consideration. And courts look at different things in order to make this decision. Now, while in some ways it's difficult to define what a legitimate business interest is, courts oftentimes will make it easier to know what a legitimate business interest is not. So courts have said that it does not include merely protecting an employer from general competition. General competition is fair game. It's unfair competition that is problematic in the eyes of the court. So to give you an example, employers do not have an interest in preventing employees from competing through their use of general knowledge or their general skill or their general experience that they've acquired through training or just their years on the job. To give you some examples of legitimate business interests that courts have identified as deserving protection are, again, that large category of trade secrets that we discussed earlier, also intellectual property, things like customer lists, goodwill with customers, knowledge of business practices and methods, profit margins, costs, pricing, and other confidential information that is of value to the company and that would be harmful if shared with competitors. Training and education, again, depending on what this actually looks like and how the information is gathered and how it's used and how it's protected, all come into play in this analysis as well. And then the element of the non-compete agreement being reasonable in scope, geography, and time is something that the court's going to essentially ask whether or not the non-compete agreement is too broad. And so they'll look kind of at all the details of the agreement, but essentially they're asking the question, is this a reasonable restriction or not? So with respect to time, is a 6-month period of time where they're not allowed to compete with with their former employer reasonable? Oftentimes where this is permitted, 6 months is going to be a presumptively reasonable period of time. The higher that time period goes, then more scrutiny will be given to it, and maybe it will reach a time period where it's not reasonable any longer. Same thing with geography. Perhaps there's a mileage restriction surrounding a location that's a reasonable geographic limitation, but perhaps a nationwide restriction would be too broad. Same thing with kind of the overall scope of the agreement. The courts will ask, is it really necessary to protect the employer's legitimate business interest, or is it going a step too far?
Yeah, and just one point there with the scope, that's something that employers sometimes forget about, but different states take that pretty seriously. For example, in Virginia, the scope of the non-compete really should be limited to essentially the same job the employee is performing. So let's say the employee does marketing, and you have a non-compete, and the non-compete should say this employee cannot perform marketing for a competitor for let's say 6 to 12 months. If you just say the employee cannot work for a competitor for 6 months, the court will likely say, well, it's not limited in scope. This is something, and I'll talk about this. There was just a recent Illinois case on this. It's called the janitor rule. That the defendant would argue, oh, I can't go work for a competitor as a janitor. This all impacts everything that Megan was talking about in the beginning. The whole reason for this is that the trade secrets and confidential information of the employer is protected. So, of course, if he's working in the same capacity, he has some sort of trade secret or confidential information, potentially has that knowledge. If he's working in a totally different capacity, for example, a janitor, he wouldn't have the trade secret or confidential or proprietary knowledge of that job. So that's what the scope means. And people sometimes only think about time or geography, but you really want to limit the scope to the same duties, or at least similar duties, that the employee performed while he was working for you.
I won't dwell too much on this slide, but just wanted to mention that some professions may have statutory exemptions that apply depending on the jurisdiction. For example, in certain industries, there may be public policy justification for exempting them from non-compete agreements. For example, some in the medical profession to basically allow the free flow of information and ideas, and to again not put too harsh a restriction on ability to move.
The interesting one there, and lawyers, some people think it's because the lawyers wrote the rule that lawyers are exempt from non-competes, although it is so the clients can have their full choice of representation. The one that I'm always surprised about is broadcasters, but for some reason there's a carve out, and I don't think it's for all broadcasters, but for a substantial amount of broadcasters, they are exempt from non-compete agreements. So I always find that interesting.
So for the next few slides, we're going to talk about kind of what do you do once you've considered hiring somebody with a restrictive covenant with a non-compete, and then kind of how do you treat that employee after they've left the employee. So first, if you're considering hiring someone with a non-compete agreement or other restrictive covenant, like a non-solicitation of customers or employees clause. So first, you want to take reasonable steps to protect your business from interfering with your competitors' restrictive covenants. So you have to think outside of your company. This employee now coming into your company may be subject to a restrictive covenant from their former employer. So during the interview stage, you can ask an applicant whether they are subject to an employment agreement with any restrictive covenants. And you can even obtain a copy of that agreement and understand what the scope of the restriction is, and communicate very clearly that the company insists on full compliance with the employment agreement. So you're making clear you're not trying to have them violate any restrictive covenant that they may be subject to.
Right.
And make clear
there. Sorry to interrupt, Megan. You might all know this, but if you don't do that, it's not only this new employee that might be sued, and then you have to start over the process of potentially looking for another employee, and it's a lot of wasted time, effort, and money, but you will be sued for tortious interference with contractual relations. And it goes from the old employer initially wanting to sue this new employee to then caring much more about suing your company, because your company has deeper pockets. So it ends up, even though this is all prudent to do, it's absolutely necessary, or all of a sudden you're on the hook for being a defendant in a case, and just saying, oh, we didn't know about the non-compete isn't really a great defense. So these points that Megan are going through right now are very important, both to be just a prudent new employer, but to protect yourself from significant legal exposure.
Absolutely. So making really clear to the applicant that agreement, the company respects that agreement, acknowledges that agreement, wants them to continue following that agreement, and really, if it's not clear in the language, making it very clear that the company does not want the applicant to disclose or use any of the competitor's confidential or proprietary data. if they come onto the company. And the way to kind of solidify this is if you do extend an offer, to lay this out very clearly in the offer letter, which can then confirm and set the expectations of the employee to comply with any existing restrictive covenants. And that agreement is a written document. It is put in the employee file, and it can be referenced if the former company raises any issue, or if you need it in any case down the line to defend against a claim of interference or misappropriation of confidential or trade secret information. But it's not enough to just leave it as, you know, a line or a couple lines in the offer letter. You really want to take a proactive approach and review with the now employee to ensure that everybody understands what this actually means in reality and how to comply, and kind of sit down with them and create a list of customers that they worked with, and kind of the scope of that work, and figure out if there if there needs to be a clear delineation of what that employee customers that employee can continue to work for, and ones that they may need to be restricted from working for. And one of the ways to do this is to create an ethical wall, so that if an employee worked with customers that they shouldn't be working with going forward, that there's a clear process for that, and that everybody who's involved knows that, so that information isn't shared unintentionally with that employee. They're not asked to perform work that they shouldn't be performing, and that kind of separation is understood and respected. And you want to, an important reason for this is to avoid allegations of flipping, where the former employer thinks that you just hired that person to then directly compete with them. And so creating these ethical walls and creating procedures to be mindful and protect against these things shows that you're taking it seriously, and that you're not trying to do anything nefarious or that competitor would have a problem with. And then the corollary to this is, how do you treat an employee when they leave for a competitor? Again, you want to take reasonable steps to secure that confidential information. So one thing you can consider is having a comprehensive exit interview where you go over, excuse me, it may have been a while since that employee signed their confidentiality agreement, or reviewed their handbook, or signed their offer letter. And so you can remind them of the confidentiality agreement, any other restrictive covenants that applies to them, so it's fresh in their mind when they leave your employment. The exit interview is a really good opportunity to collect any company issued property, cell phones, computers. Ask that they remove any employee information from, personal computers or devices, or things that they may have printed out over the years. It's also one thing here is about returning company issued property, is that's something that I mentioned earlier on when considering a confidentiality agreement or language to put in your handbook, that you've put out there since the very beginning, that if an employee leaves the company, they will be asked to return everything. So then in the exit interview, when you ask them to return everything, that's expected and they know how to comply. You want to, of course, remove employee access to computer networks or emails or servers. And then if they do have any laptops or desktop, any hard copy, anything, that you take all that back, but then also really consider hanging on to that information, because if you have, say, an employee who leaves for a competitor, and then an issue arises down the line, and there is a concern that they may have taken trade secret information, or they may be misappropriating this information with their new employer, that you have the ability to check their hard drive do a forensic analysis if need be and find out what were they doing before they left the company, and is there any evidence that they've taken trade secret or other confidential information. And then you can even contact their new employer and just notify them of the employee's obligation under their employment agreement, because the competitor may not be taking all of the prudent steps that you are taking in reminding new employees to comply with their existing agreements. So you can really, like any kind of tricky issue in the employment realm, I like to say that messaging really matters. And so you can really fight for your customers and business in a very positive way by communicating publicly about new hires. So you can identify, you brought somebody new onto the team, you can identify them publicly. You can, shoot out a message in your whatever social media you use or whatever advertising or communication you use to say, hey, we have a new person on our team. You can kind of facilitate the new relationship between this new team member and your customers or vendors or other business relationships, especially those that you may be concerned about, to say, hey, you're in good hands. Here's our new team member. You are in good hands with this person, and make sure that you solidify that relationship. And the emphasis can really be on why your customers or vendors or whoever should continue to do business with you, and rather than putting the focus on not doing business with the employee who has since left. And really careful consideration needs to be done to make sure that there's no false information or defamatory information being shared about the former employee. When in doubt, simple is best. Clear communication that the former employee is no longer with the company, and really leave it at that. You can't control all communications with your workforce. You can't protect against all gossip, but to make really clear that if there are rumors spread about a former employee, particularly when they are not accurate, that can give rise to liability on behalf of the company for invasion of privacy or defamation or other such claims. And you can certainly make clear if there are questions about, well, what can we say, what can't we say, to make clear how the employees who remain can legitimately communicate about a team member's no longer being there. Generally speaking, an employee has the ability to use their kind of general knowledge, skills, and experience to compete with a former employer. But again, along the lines of avoiding unfair competition, it's pretty consistent nationwide that employees cannot use confidential information or trade secrets that they acquired during employment to compete with that former employer once they've left, or even during the course of employment. So if there's questions when somebody leaves and it raises these questions, it's a really good time to remind your employees about the expectations that are hopefully laid out in their confidentiality agreement or the company handbook. And again, to keep in mind, if you're considering whether you have an issue on your hands or not, you can investigate whether an employee may have taken confidential or trade secret information. You can, rely on your forensic abilities or your abilities to check their emails or their other communications to find out, are they potentially misappropriating trade secrets? Are they potentially soliciting customers in violation of a restrictive covenant, either while they were still working or after they've left, depending on what the scope of the agreement is? Have they solicited other coworkers to leave? If that is something that's subject to the agreement, And have they really walked away with information that is of value to the company that could be of great value to a competitor? And some other kind of detailed steps that you can take. You can, not only make sure that you don't reissue a device, but you can make sure that you're saving emails, make sure that, any information that you might want to turn to find out what the employee was up to or what the employee might have taken or forwarded to a personal email address while they were still employed. Make sure that you have the ability to capture that information if you need to. And, this sort of, if you are at this level where you are investigating an employee, this is certainly something to be very careful with in terms of who knows this. You don't want to open yourself up to, like I said, an invasion of privacy or defamation lawsuit. And this is just a list of, depending on your operations and where information might be stored, these are some things to consider in checking when you might have an issue on your hands, like a personal computer, the employee's email, voicemail, a company smartphone if one was issued to that employee, but even cell phone records, not just the physical phone itself, but also the cell phone records, if that might show phone calls that the person was making before their employment ended, phone numbers that they were dialing, phone numbers that were making calls to them. Also card access records to show if that shows where they were, or what they may have had access to. Same with video surveillance cameras. So at this point, we can move on to the much anticipated updates from Jordan.
Thank you very much, Megan. Yeah, just in summary, there is both federal movement on this issue, although the federal movement isn't substantive, and then just a ton of state movement. Really, the states were kind of quiet for a while. California had their rule that everyone knew about. Other states had their case law, but really in 2018, when Massachusetts, they kind of jump-started this trend and instituted some harsh requirements in terms of the effectiveness of non-compete agreements, specifically for low-wage workers, which is something that a lot of states have grabbed onto. And since that time, there's over a dozen states that have issued non-compete laws, and I'm going to go through them real quickly, knowing that everyone on this call is from different states, but just to make sure what's going on in your state. But before I do that, let me just talk about the federal update really quickly. In July, the Biden administration issued an executive order, I think it was called the Promoting Competition in the American Economy order. And it didn't necessarily do anything immediately, but it encourages the Federal Trade Commission to, as it says on the slide here, curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. So, the question is, well, what exactly does that mean? In the past decade or so, there have been calls for federal agencies to curtail the use of non-competes. But this is a little more, even though it's not substantive, it's more direct than anything that's ever happened on the federal level before. And keep in mind that in Biden's campaign, he did stress that he would like to eliminate all non-compete agreements, except for the very few that are absolutely necessary to protect the narrowly defined category of trade secrets. So this order, is a step towards fulfilling that campaign promise. So, we're going to see what happens if somehow the federal government does join the growing number of states that actually institute legislation. But for now, there's nothing to do from a federal standpoint. However, some of the things Megan discussed, you do want to be on the lookout about whether your non-competes are narrowly tailored and impose no greater restraint than necessary to protect your interests. You know, are they reasonably limited in duration and geographic scope and scope of duties? Do you have low wage workers? Now, and again, I'm going to get to that in a second in various states, but at this point, the momentum is huge to basically eliminate non-competes for low wage workers. And, you know, just another general tip is you want to make sure that you don't prevent an employee from doing business with clients or customers with whom they had a relationship with prior to your employment. And then are there confidentiality or other provisions, non-solicit, that you can do instead of non-competes? So that's just things you want to think about. Then going to some of the state rules, and the big one, I mean, there's a bunch, but the real big one here is in Washington, D.C. It is not in effect yet. It will be in effect in a few months in April, although it's gotten pushed back once or twice, and it's possible it'll get pushed back again. But you know, this really makes DC the most stringent non-compete law anywhere other than California, I believe. It really prohibits non-agreements for virtually all employees. There's one or two extremely limited situations. I think you know, you have to be over $250,000 and a specific medical professional, and that's it. But the really big thing is it goes further than that. It bans anti-moonlighting and other workplace policies which prohibit an employee from performing work or for being employed by any other person, even a direct competitor, or operating your own business. Again, this is during the employment, not even after. Many clients have some sort of anti-moonlighting provision, and those provisions will not be valid in a few more months. There is also a specific notice that DC employers will have to provide their employees, basically saying no employers may require you to sign any sort of non-competition agreement. So that is something, in case an employee somehow doesn't know, you will be violating the law even if you don't give this notice. So, you know, there's just so many things. It provides a private right of action for the employees. It does permit the employer to still have protections regarding confidentiality. So at least the law does not ban businesses from entering into agreements with employees that prevent the employee from disclosing confidential, proprietary, or sensitive information, customer lists or client lists, or trade secrets. However, any agreement regarding protecting the sensitive information cannot restrict an employee's access to new or other employment opportunities in the course of enforcing those protections. If you want to move to the next slide, Megan, the one interesting thing is this law doesn't mention non-solicitation agreements. So at this point, we don't really know if non-solicits will be prohibited or not. You know, for now, we're focused on making sure our clients know that the anti-moonlighting provisions are now something we need to be aware of, and just general non-competes. You know, and this act, again, is so unique in prohibiting DC employees from performing other work while employed. And that's just something that our clients are having trouble getting their heads around. And quite frankly, you know, I'm having trouble getting my head around that. And the other thing is, in addition to non-compete agreements and anti-moonlighting agreements not being valid, the act also impacts other commonly used employment policies, because the moonlighting provisions could affect standard duty of loyalty and conflict of interest policies. Yeah, I've reviewed for clients a bunch of conflict of interest policies which typically precludes some sort of conflicting employment during an employee's time that they are employed. And those conflict of interest policies, especially lots of government employers have conflict of interest policies, those may not even be valid anymore. So it's going to be very interesting to see what happens in DC. Real quickly, going to some other states now, because I do not have a lot of time here. There's going to be a big theme here for both Maryland. One other thing about DC is it will only apply to new agreements going forward. It will not apply retroactively. So at least that's one thing employers can breathe a sigh of relief. Both Maryland and Virginia, talking about the DC area here, are now prohibiting employers from requiring low-wage employees to enter into non-compete agreements. In Maryland, similar to DC in a way, although it doesn't ban non-competes, but this ban on low-wage non-competes does apply during employment, not just after an employee leaves. That is not the case in Virginia. But again, both Maryland and Virginia, if you have low-wage employees, you want to be extremely careful not to have them enter into non-competes. Similarly, if you look at the Illinois law, which I think is 2 slides up, that goes into effect in about a month, the start of 2022, which is the same, similar, although the Maryland and Virginia, the wage threshold was much lower. In Illinois, non-compete agreements will be banned for employees earning less than $75,000 annually. And then that annual salary threshold will increase over time. And the interesting thing in Illinois is that non-solicit agreements will be banned for employees earning less than $45,000 a year. All these states have just little interesting carve-outs that other states don't. And Illinois is interesting in that they have this carve-out, not just if you're terminated, but if you're terminated or furloughed due to COVID-19 or something to that effect. If that's the case, then the restrictive covenant would not be able to be enforced. A handful of other states I just wanted to mention real quickly. Washington State, they are now void and unenforceable for employees making less than $100,000 annually. Also, Megan had talked earlier, about various time limitations. It is now a presumption in Washington State that if the non-compete is longer than 18 months, it is unreasonable per se. So, that is something to keep in mind. A few other of the states out west, Nevada law just went into effect, last month, that non-compete agreements may not apply to employees who are paid on an hourly basis. And that law also precludes employers from restricting former employers from working for a prior customer or client if the employee did not solicit. So if the employee was at a company and they didn't solicit the employees, the clients they work for, they can now work with those clients going forward. Oregon, similar to Washington State, has now reduced the maximum length of lawful restricted period, not only from 18 months, as Washington State's was, to now 12 months. So if you have a non-compete with someone for more than a year, with very limited exceptions, the non-compete will be invalid. And again, I don't know the breakdown of everyone on this call, but if you're in any of these states I'm mentioning, you really want to keep these issues in mind and talk to me or someone else to get more details. And then the last 2 states I'll just talk about real briefly, and then I know I have to let you go, is New York and New Jersey. Now, unlike the other states I mentioned, New York and New Jersey do not have laws as of right this second. However, the trend will continue And the proposal in New York is that it would prohibit the use of non-compete clauses in their entirety, provide no exceptions, and have, in addition to, you know, regular damages, liquidated damages of up to $10,000. So if that's passed, obviously that would be a huge change. And then going to New Jersey, a bill also was proposed a few months ago. It would be a little bit different than New York, but it would limit non-compete agreements to terms not exceeding 1 year and provide various restrictions for the reasonableness of a restrictive covenant. And like many of those other states, it would prohibit non-competes regarding low-wage employees, although they did not define what a low-wage employee would be, although it would probably be higher than how they define it in other jurisdictions. And as with New York's bill, it also contemplates liquidated damages. So if I mentioned your state, you know, you somehow didn't know about these restrictions, you want to look into that ASAP. If I didn't mention your state, these things are coming down the pike anyway. So, you know, you really want to be careful with your non-compete issues going forward. We did not have time to talk about forum selection provisions. If that's something you're interested in, you could just email me, and, you know, we could discuss whether or not you're in a state that the law is a little bit more harsh. We're almost done with our 2021 labor and employment webinar series. In December, there'll be a recap of the Biden administration, but, you know, stay tuned where we'll have our 2022 series coming up shortly. Feel free to give us a call or drop us an email if you have any other questions on this issue. And we enjoyed presenting, and we hope you enjoyed listening to our webinar and found it useful. We look forward to speaking with you all again very soon. Thank you very much.